हो गया सर, लाइव हो गया।
मेरा में लाइव नहीं आया। यस आ गया।
जब आप बोलेंगे
Yeah, we are going to start. But 1 second. YouTube is running fine, perfect. Your recording is up.
नो,
Up.
जब आप बोलेंगे स्टार्ट कर देंगे।
हाँ, up करो ना। Please start recording.
This meeting is being recorded.
Yeah, पुरानी साहब start कर ले।
Yeah, am I audible?
Yeah, please start, sir.
Yeah. Good evening and warm welcome to insolvency professionals, bankers, and members of our company, Persistent Insolvency Professional Private Limited. Today, that is 19th November 2002 at 6 p.m. I am Rajendra Puranik, Director of Persistent Insolvency Professional Private Limited. We are a group of 126 insolvency professionals all over India, and valuers also. We have got 21 valuers all over India. Our company was incorporated on 14th February 2022 with head office at Hyderabad and corporate office at Narian Point, Mumbai. Other directors and promoters of the company is Mr. KJ Will, who is our founder promoter, Mrs. Ramila Rangaswamy, Mr. Anup Prakash Awasthi, Mr. Narasimha Prasad, Dr. Nanda Kishore Singh, Mr. Paramjit Singh Sethi, Pradeep Kumar Kaushik, and Mr. Vimal Kumar. And some other directors also joining maybe shortly. We have 127 offices all over India with 127 panels. Rather, we can say we have 127 IP all over India. So the offices are there all over India and with 15 NCLTs from Allahabad to Cochin and from Rajasthan to we can say Kolkata. Our team is made of CAs, cost accountants, company secretaries, bankers, advocates, valuers in all three categories of plant and machinery, land and building, financial assets. Across India, we have handled almost 140 cases through our insurance professionals. We have an advisory board of highly experienced persons who have done experience of monitoring 2,000 IBC cases. Then they have got MDs of companies, ex-chairman of the banks, Supreme Court advocates. Our website is www.persistentinsolvencyprofessionals.com. You can give any suggestions. Last 8 months, we are having a series of these webinars. Every highly lovely professionals, Mr. Kumar sir also is there from IBC field. He is the ex-GM of Union Bank of India. He is an advocate after retirement. He is going to give lecture on proper and initially we are IPs. We know how to handle practical experience. Now we are not able to. Our Panigrahi sir is going to give us insight into the MS resolution process under IBC. Over to you, Vinod sir.
Yeah, thank you, Mr. Puranik, for the detailed intro of the company. I'm not taking much time, but I just want to tell you something. PPPR, but Puranik Panigrahi sir is going to present. Actually, it is not picked up the is rhythm. MSME resolution, it is not picked up its rhythm. The reason being, see, this case is not initiated by financial creditor or operational creditor. This case and a resolution of MSME is to be taken care by the MSME itself. And because of that, there is a lot of knowledge sharing process is required to reach to the MSME. They are suffering with the stress as such. This is the only reason why it's not picked up its rhythm. Now, in this scenario, as an insolvency professional, we may not found any cases or rare cases is come up into the system. There are two reasons broadly. Some MSMEs are funded by the government backed funding. So as far as concerned, those funds which are secured for the banker because it is an assured fund, assured debt backed by the government guarantee. So the MSME team, MSME owners may not be much that worried, or the banks may not be much worried. But those cases are important where such loans are not bank guaranteed, government guaranteed, and those promoters are aware about the PPIRP process. These are the two area. Because of that, it is getting into a slow, almost stagnant position. My voice is audible properly? Fine, fine. So now in this process, while looking into the caption, many of you may have a problem. Why opportunity to the chartered accountant? Yes, it is very dominant that they can only able to get the first information report about the CD and its health. They only knows about what is the issues and what is the problem with the MSME in which they are practicing either as an auditor or as a practicing chartered accountant in somehow or other how. Of course, there is a interaction with the company's secretaries, but if company secretaries while uploading their annual return etc, if they can also able to help this MSME to put the knowledge about on their trust, well and good, but generally they will also busy with their return filing and they may keep it away. But as far as concerned to a chartered accountant, as an auditor, as a consultant, or a GST practitioner, or an income tax practitioner, he can able to identify which are the MSME actually it's require a clarified approach of getting utilized the provisions of MSME resolution PPARP. That is the reason why we are highlighted the opportunity available for chartered accountant ahead. Even if this PPIRP is not picked up its rhythm, but it is having a tremendous opportunity behind it. But only thing, it should be taken care by the person who is known to this issue, and then it is to be tracked to an insolvency professional if their firm or company is not a insolvency professional member is involved. So this is the topic where we are going to get. I just wanted to get given glimpses of the reason why the chartered accountant word is highlighted there. Yes, we are now in a process of calling of interacting with the most of the MSME across the country in a wide platform to discuss all these issues with them, whether they required a restructuring or a resolution or something like that. I also come across with many situations that many companies are insolvency. Wonderfully, they are MSME having the ODM certificates and all those things. When we are inquired about this, I'm not aware, sir, is there is any possibilities there. See, if they could have aware about it, well, it could have been taken at the very young stage and it could be resolved in an amicable way. Now certain cases are reached at the end of the CIRP and in the middle of the liquidation. Now at least we could able to educate them and make them to use the platform in the way it is required. So this is what I just wanted to convey the message in toto. Right. So this is the time I'm just requesting Mr. Paramjit Sethi to come forward and address the group, and then we will go for Mr. Panigrahi sir to deliver his speech. Before that, I just want to introduce Mr. Panigrahi. He is MA LLB, CAIIB, Diploma in Corporate Law, Diploma in Cyber Law, former General Manager, Union Bank, Advocate, and IP. He very associated with the risk assets management, DRT and SARFACI, debt restructuring and debt management. Looking into the experience and vast experience of Mr. Panigrahi sir, it is very useful for us understand what is in depth behind all these PPIRP and why it is not picking up its rhythm and what are the things we can do going forward, so that the biggest pillar of our Indian economy, that is the MSME sector, could be saved when other corporate are also taking care of their activities in a wide manner. So this attempt is giving a helping hand to the all MSME across the country, so that they could able to understand better about the packages available under insolvency before they themselves declared it under insolvency as a bankrupt or a liquidation process or something like that. Over to Mr. Paramjit Sethi. Thank you.
Thank you, sir.
Thank you.
Uh, in my opinion, why this PPIF is not become popular? The reason is awareness among the CDs and bankers. This PPIF is better than CIRP for MSME because the business will be in the control of the CD in this case. So it is a better proposal as compared to CIRP. That's why we have selected this topic, so that our members and bankers can be aware and get the benefit of this. I will not take much time between you and Mr. Panigrahi. So thank you all for joining, and please have the knowledge sharing session from Mr. Panigrahi. Thank you.
Thank you. Is the screen visible?
Yes, visible, sir.
Okay.
Can you make it?
Yes, visible.
Yes, sir,
Okay.
visible.
Thank you very much for providing me this opportunity in this August evening to present on behalf of PIPPL the process of pre-pack insolvency resolution process. Dear friends, actually micro, small and medium enterprises, they have been contributing greatly to the growth of Indian economy, including the employment generation process. As on date, there are approximately 27 lakhs of registered MSMEs in India. As we have seen in the previous period, government suspended the filing of applications for initiation of corporate insolvency resolution process. And that too, the CIRP in respect of the defaults arising during 1 year beginning from 25th of March 21 up to 25th of March 2020 up to 24th of March of 2021. In recognition of the role of MSME and to offer the respite from economic challenges due to the ongoing pandemic, a pre-pack process, that means PPIRP, was introduced by Ministry of Law and Justice, Government of India, by way of IBC Ordinance 2021. That was passed on 4th of April 2021. There was great apprehension among the stakeholders whether it will be practically successful or remain on the papers only. And this is also a debate as on date. Government considered basically that it is expedient to provide an efficient alternate resolution mechanism to ensure fastest, quicker, cost-effective, and value maximizing outcomes for all the stakeholders. And that too in a manner that is least disruptive to the continuity of their business and preservation of jobs. So we'll go step by step. What are the basic objectives? So enhancing availability of credit, providing for a time-bound resolution, developing entrepreneurship. All these are basic objectives enshrined in the process of PPIRP. So two broad process, CIRP, that is resolving stress, and through resolution or liquidation, PPIRP, it resolves through a resolution plan or closes without a resolution plan. So what is this pre-pack? Pre-pack is a resolution of the debt amount through an agreement or an arrangement with the secured creditors. It is nothing but restructuring with consensus from the lender. It is a process of restructuring with a consensus from the lender. So what is its applicability basically? Who can apply? The CD can only apply. Neither FC nor OC can initiate the process. So what is the threshold? Basically, let us know the threshold. MSME may trigger the PIRP process for defaults amounting 10 lakhs and up to 1 crore only. For defaults of higher amount, MSME have to resort to CRP process. So we have already explained what is a pre-pack and available for the amount and why is it so. That also we have explained to ensure a quicker and cost-effective litigation-free business continuity process, reducing and preventing stress and NPS, and CD in the control of the management, preventing and value maximizing outcomes for all stakeholders. That is the essence. So what are the prerequisites? We'll go one by one. Before that, we'll read what is the what exactly the benefits to the stakeholders and the economy, how it is getting a reaction, and what is the purpose and benefits that it will be providing. It is a consensus-based approach to save the viable MSME units in a time-bound manner. It reduces the burden and dependence on NCLT. It is a judicial seal of approval. It is a resolution plan before the unit goes for bankruptcy proceedings. It gives an opportunity to the CD to start afresh while safeguarding the rights of all its stakeholders. Most important that it prevents downgrading of accounts, very interesting for the bankers, and it helps the borrower, MSME borrower, to restrict to get interest rate benefit. No higher interest rate will be applicable. Basic intention for bank is to avoid the court process and litigation time and expenses. So all these are there. And what is the need for the bankers? Need is to have an expertise in IBC. Expertise in IBC, legal infrastructure, legal literacy, monitoring, credit monitoring, and credit risk management practices at a broader industry level for the bankers. So banks to detect the SMA2 accounts, especially EWS, sickness, and initiate the process. Bankers to venture for best available plan. Even restructuring, SURFACIA, DRT, CIRP are cost involved. So banks to foresee the economic contribution of keeping these MSME units live. So prerequisites that the corporate person, those who are classified as a MSME, they should be a company, those who are company as per the Company Act 2013, LLP, those which are registered as MSME under MSMED Act, that is mandatory. That is mandatory. MSME LLPs registered under MSMED Act in 2006, because it is in one case in Kerala, Silpi Industries, that has been decided. Court has given a verdict that it is to be registered under MSMED Act. However, this doesn't include any financial service provider. So corporate person should either be engaged in the manufacturing or production of goods in any industry or engaged in providing or rendering services. Then only it can be eligible. So what are the broad features? We'll go one by one. So features are that an application is to be submitted, and the applicant, the corporate debtor, if it is a company, it should have 75% of its shareholders' approval. If it is a partnership firm, it has to be with an approval of 3/4 of its partners. And it should also get the approval of unrelated financial creditors. They should represent on UFC should be 66% in value of the total financial debt due and payable by the applicant. Then only the applicant will be eligible. Other checks and balances, the applicant should not be undergoing or has not undergone either CRP or PPRP during a cooling period of 3 years prior to the PPRP initiation. And there should also be no liquidation order passed against the applicant. And applicant should also be eligible to submit a resolution plan. Then 66% in the value of the financial creditor unrelated to the corporate debtor need to approve the proposal. The majority of the directors or partners of the corporate debtors have to file a declaration also. What is the declaration? That the corporate debtor will initiate the process within 90 days. Process is not initiated to defraud anyone, and it must also declare the name of an IP and to be approved by that name is to be approved also. So we'll go one by one. CD. Let us briefly outline again. CD, it must be under 7(1) of MSME Act. Default at least 10 lakhs. Section 29A eligibility must be there. It must not have undergone or not undergoing CRP process. No order as per section 33 is passed under IBC for its liquidation. Regarding meeting, CD shall convene a meeting of UFC, UOC under section 54A, 2E and 3. And there should be a notice indicating the time, date, venue and agenda items. Resolution professional, creditors having at least 10% of value of the debt to propose the name of IP to be the resolution professional. UFC representing 66% at least in value of the debt to approve the appointment of IP as a RP, including its terms. Then special resolution to be passed by 75% of the shareholders in case of a company, or 3/4 of the total number of partners in case of LLP. Then base resolution plan, the CD shall prepare. So let us see what are the timelines. Basically, the total timeline defined is 120 days. How this 120 days goes? And what are the contents of section 54A? The section 54A, B, C, D, all these up to P, these are very, very important. Section 54 is very important in PPIF. So before that, we'll discuss about the timeline. Timeline is 120 days from the date of admission by adjudicating authority. That is to be completed. The process is to be completed within 120 days from the date of commencement. Within 14 days of submission of the application, adjudicating authority should either accept or reject. But before rejecting an application, there is a leverage. Before rejecting an application, the adjudicating authority, it directs for rectification within 7 days. it gives a notice for rectification, if any, in the process of admission. So if it is accepted, then it is stated that it is commenced. So it is told the date of commencement date, and adjudicating authority shall declare a moratorium in relation to the applicant. So 54A, it speaks about CD's eligibility. 54B, duties of RP before process. C, application to initiate the process. 54D speaks about the time limit of the process. 54E, declaration by adjudicating authority of moratorium, RP and announcement. Then 54F, duties and powers of RP. 54G, list of claims and information memorandum. 54H, management of affairs of CD. 54I, committee of creditors. 54J, vesting of management of CD with RP. 54K, consideration and approval of resolution plan. 54L, approval of resolution plan. 54M, appeal against order section under section 54L. This is the broad parameter section wise. If someone goes in detail through this particular section 54, he or she will be thorough about the process. So what happens? It is bifurcated into 90 days and 30 days. Out of 120 days, 90 days and 30 days. What is this 90 days? Within 90 days, resolution plan. 90 days means 90 days from the date of admission of the process. RP should submit the resolution plan. And another 30 days, that is approval of resolution plan. So this is 120 days bifurcation, 90 days and 30 days. So here we come across the duties and responsibilities of RP. Duties and responsibility of RP, duties and responsibility of corporate debtor, duties and responsibility of the creditor, and contents of best resolution plan and best alternate plan, and process for approval. What are the basic process for approval and the role of NCLT? So what we observe, basically, we have already discussed all these things. So date wise we will go. So what are the documents required? The record of default, and in the process declaration, declaration by directors, partners, declaration by CD, all we have discussed. So here AFS for last 2 years, that is required, and PFS, provisional financial statement for the current year, that is required to be submitted, and MSME certificate, that is mandatory, and a fee of 15,000 per application, that is also essential to be deposited. So date of commencement and date of admission until approval, 120 days. Let us just briefly highlight. Date 0, commencement date and date of admission. Within 2 days, CD is to submit the list of claims, list of creditors, their security interest, guarantees, information memorandum, and base resolution plan. Within 2 days, these are to be completed. Then 7 days, constitution of COC based on the list of claims confirmed by RP, COC. Then within 14 days, 14th day, first meeting of COC must be completed. 21 days, invitation for resolution plans and selection as best alternate plan with highest score. Scoring system is there in every plan, if it is required. 90 days, approval of plan by COC and submission of approved plan to adjudicating authority. Then 30 days for AA, either for approval or rejection by AA in the process. So PPRP closes. So on approval of BRP and BAP on expiry of 90 days, on rejection also, these are the basics. So here we'll find what are the pre-process issues. The mutual understanding, list of creditors, identification of IP. These are the pre-process. Declaration by the CD, shareholders resolution, consent of the majority of unrelated financial creditors, report of RP, application to adjudicating authority for admission, and updated list of claims, preliminary information memorandum, and submission of base resolution plan. These are the basics required. So before the process, what is the basic? What are the basic duty and responsibility of the resolution professional? And what are the duties basically? We see we have already mentioned CD and applicant, creditors, and resolution professional. Resolution professional role comes in two divisions. One is before the process and one is during the process. After the process, there is no role. So before the process, what are to be done by the resolution professional, or what are his duties and powers or responsibilities? So before the process, he is to prepare, RP is to prepare a report that CD is eligible. His eligibility is to certify. CD is eligible to initiate the process. He is to prepare the report that the BRP submitted by the CD is in compliance with the provisions of the code. That is also another certificate he is to prepare. It is to be submitted. And third report, that is public announcement of the initiation of resolution process in case of a corporate debtor, he is to go for. Then claims, he is to confirm the claims, inform the creditors about the claims on CD, maintain the updated list of claims, constitute the COC, prepare information memorandum, monitor the affairs, intimate COC about the breach of any of the obligations by the management of the CD, and also file an application for avoidance transaction, PPPIF transaction, if any, before the appropriate authority. That is before the process. So during the process, what is the role of RP? During the process is to go for access of the books of accounts, records and information available with the CD, either physically or in the electronic form or mode available with any information utility, or with the government, or with any statutory auditor, or with any other specified person. That is mandatory. That is within the process, during the process. During the process is to attend all meetings of the management of CD and board meetings also. Then in case of a necessity, he is to engage accountant or other professionals, collect all the information during the process about the assets, about the liability, finance, operation of the CD, and its financial position, and existence of any avoidance transaction or fraudulent transaction, or that we say PPPIF transaction. So this is before the process and during the process. Then what is the duty of the corporate debtor? He is to identify the FC and OC, prepare a list and amount due. Then meetings of creditors and seek approval of appointment of RP, arrange the financial statement, declare the avoidance transaction, preliminary information memorandum, and list of claims, base resolution plan, and submit it to RP, manage the CD as a going concern, and protect and preserve its value. That is the basic duty of a corporate debtor. So within 2 days, he is to complete, CD is to complete, prepare the list of claims with details, security, interest, and guarantees. And within 2 days, he is to prepare an information memorandum containing the information relevant for formulating a resolution plan. That is duty of the corporate debtor. Creditors, they have to approve the name of IP to act as RP, filing of application, and initiating the process, for initiating the process. Active role in evaluation of the resolution plan. This is more important. Evaluation of resolution plan, considering the plan, and creditors may resolve to initiate CRP in respect of the CD also, may resolve. So Now, since it is a change in strategy, if we compare CRP process and PPRP process, there is a change in strategy. Basically, it is a creditors in control model to a debtor in control model. Now, purely debtor in control model for resolution. Let us discuss about the base resolution plan before going for that slide. This is the main slide. I'll come, but before that, we'll discuss base resolution plan. Base resolution plan, who is to submit? The applicant is to submit. Submit within 2 days from the commencement date, process commencement date. And whom to submit? It is to be submitted to the resolution professional and the unrelated committee of creditors. Very, very important. Submission of base resolution plan. Why it is to be submitted? It is to be submitted for consideration. Once this BRP is presented, the COC may approve the BRP for submission to adjudicating authority. Once COC approves, it is to submit to adjudicating authority. Very simple process. And it is to submit provided it doesn't impair any claims owned by the applicant to the operational creditors. Now let us come to different situation where COC doesn't approve the BRP or the BRP impairs any claims of the operational creditors. What happens? Then in that case, the RP is to invite prospective resolution applicants to submit resolution plan to compete with the base resolution plan. Now there will be a competition of other alternate plans with the BRP. That means now it is now the matter of Swiss challenge method comes. Swiss challenge process is in vogue now. However, COC is also empowered to provide the applicant the opportunity to revise its base resolution plan prior to inviting the competing bids. So the utility here in and the best opportunity for CD is again to revisit once to rectify the deficiency in the application process, now to revise the base resolution plan. So when the alternate plans are received from the potential bidders, COC evaluates the resolution plans and chooses the best one that is compliant with the criteria set and superior to base resolution plan. If it is not superior, it cannot be selected. If there are no competing bids, there may be a situation there cannot be any competing bids. So in that case, what will happen? The COC may proceed with the base resolution plan only. So bids are to be sought. If bids are not there, the same BRP is to be worked out. Now, the resolution plan or base resolution plan must be approved by the COC with at least 66%. This is a criteria, 66% of the voting share and presented to the adjudicating authority within a period of 90 days. So there are two slabs of time, 90 days, 30 days. Within 90 days, this resolution plan is to be submitted to adjudicating authority for its approval or otherwise. 90 days from the date of commencement. So consideration and process for approval. This is another point of the resolution plan. So this resolution plan is presented by the RP to the committee of creditors. So when the plan is approved with a members having not less than 66% of the voting shares, and it is submitted by the RP and approved by COC to the AA, and if AA is satisfied that resolution plan submitted by the RP is in conformity with the provisions of the law, then within 30 days of the filing of application, it may approve the resolution plan, and it must also be satisfied that the COC meets the requirements under section 30 of the code. This is very, very important. At adjudicating authority level, NCLT is to be satisfied that the plan meets the requirements under section 30. This point is very, very important. 30 of the code. Then NCLT by an order within 30 days of the receipt of such a resolution plan, it will approve the resolution plan or otherwise. So let us speak what are the advantages then of this process. We are discussing about PPRP, its importance, basics, everything. What are the advantages over this process? We'll go to the differences in a different slide. What are the basic difference between PPRP and CRP? But before that, what are the advantages? Advantage is the time limit, 120 days. It is designed to be completed in a period of 120 days. And it is a cost-effective process. Cost is always borne by the CD. So further spending money, but is not required. It's a control also remains with him. That is another advantage. No litigation from the CD is also expected in this process, PPRP. So there is control of business, and hence litigation is absolutely nil. CD prepares its own base resolution plan as per the business viability and underlying security. And it is always prepared with the prior consent of the financial creditors only. So that is another advantage. RP is not required to run the unit, and RP concentrates on the resolution plan only. So what is the important feature here? The approved resolution plan is binding on all the stakeholders, that is FC, OC, including IT, GST, and other authorities, including its the due, the past and past defaults and yields, everything. So what are the checks and balances we have also discussed? So we are no more repeating the important checks and balance that it should follow section 29A clauses except clause C and H. We'll go now to explain the process, how it happens. CD submits to BRP. CD submits the BRP, base resolution plan. Now see, base resolution plan, it impairs operational creditors or doesn't impair. If it doesn't impair, then COC may approve. Then if it is impairing, if it is yes, then basis of evaluation is disclosed, alternate plans are invited, and best alternate plan is selected. The first process. Next. See, let us go here. Alternate plans. No plan is received. COC may approve winning plan or best alternate plan. There are two issues. When no plan is received, again we go for COC may approve the best resolution plan. When no plan is received, COC to approve the best resolution plan. When plans are received, COC may approve the winning plan or the best alternate plan. So when COC approves, plan is, if it is approving yes, then plan is submitted to adjudicating authority for approval, 90 days. If COC is not approving, then PPPIF closes without resolution. Friends, if you see this slide, the idea of process will be fully clear to you. In this slide, the process itself is made clear. So, best alternate plan, if it is not approved by COC, PPPIF is closed without resolution. If it is approved, submitted to AA for approval. Now coming to best resolution plan, COC approves. Sorry. Now, when COC approves the best resolution plan, here it is a best alternate plan, here it is a best resolution plan. So right side is the best resolution plan. Now it is submitted to adjudicating authority for approval. Plan approved or not approved. If it is not approved, the same thing. Prepack closes without resolution. If it is approved, prepack closes with a resolution. The process is complete. So this is the important one. Now we will go again. What are the benefits basically? Let us find out what are the benefits. It's an alternative resolution process mechanism for rescue of viable business units. It is cost efficient. It is a hybrid framework because approval of creditors out of court and adjudicating authority both are required. It reduces court process and litigation expenses. Rights of operational creditors are protected. Resolution plan by management. Binding nature of the final order. Debtors in possession model. It's a strong protection against business disruption. So what are the challenges? We'll go to the potential challenges. What challenges are being faced in getting PPIRP implemented? See, MSME is not registered under MSMED Act. They are deprived. Friends, 4 to 5% of the MSME units are registered. Rest others are not registered. This is the biggest challenge in the industry, and for MSME units to go for the benefit of PPRP. Approval of 66% of FCs. That is a challenge because a distressed company may not be able to bring the financial creditors on board. It's very difficult. Practically it is difficult. As a banker, I am telling. Then over reliance on the board and thrusting of the responsibility of reviving the company may not give a desired result. That is another challenge. Then specific guidelines on rights of stakeholders. That is another challenge. When a certain percentage of creditors oppose initiation of the process, that is another challenge. These are potential challenges in the process. So let us make a summary of this issue. In summary, we'll say it is a modern timeline. RP to file resolution plan for approval or an application for termination within 90 days is very, very important. RP to file resolution plan for approval or an application for termination within 90 days of commencement date. This is essential. All other activities related to the claims like PIM, then appointment of registered valuer, constitution, meetings, evaluation and approval of resolution plan, they are all duly prescribed with a defined timeline in IBC section 54 and IBC regulation 19, 38, 41, 43, 47 and 48, and forms professionals to use form 1, then form P1 to P13. These are codified through regulations. So nothing difficult, it's very easy process. So in a liquidation process, how it happens? Unlike CIRP, COC cannot decide to liquidate in case of a corporate debtor. In case of a corporate debtor, in case of a PPIRP. Adjudicating authority shall pass an order vesting the management with the resolution professional. In this case, when no resolution plan happens or no resolution plan gets approved by the COC within 90 days, adjudicating authority shall pass an order for liquidation. And when it is contravened by the CD, then there will be an order for liquidation. So these are the basics we discussed, and let us compare this process with compare CRP and the PPRP. Eligibility criteria we have already discussed. MSME, including COVID-19 default. Here in CRP, it is all corporate debtors. Threshold limit is also prescribed 10 lakhs and CRP 100 lakhs. Initiation only by CD, whereas in CRP it is FC, OC or CD. Timeline 90 days. Here it is to submit the resolution plan, max 120 days, 180 days, extendable up to 330. Management control with the CD. Management control, creditors in control. Resolution plan, first right of offer to CD only. Whereas in CRP it is EOI, invited from all prospective applicants. If the process fails, termination or liquidation or initiation of CRP, here it is when the process fails, it is liquidation, termination with minimum 60%, 66% COC votes, where it is 90% of the voting power of COC. Cooling off period 3 years between two pre-pack. Here it is 12 months between two CRPs. Friends, as a professional, this PPRP process for professionals, CAS especially, how it is important, how they can reap the benefit of. This is the major point, how our associates can get the benefit of. It is the advisory role. Advisory role, they get advisory role, not only the PPRP, they get advisory role for CD, for creditors, especially for bankers, for prevention of slippage. It is a role of guidance, providing guidance on improving the cash flow and cost reduction to the CD in the process. The professionalism caters to revival strategy, how the units can be revived, that to timely revival. CS are capable of preparing best resolution plan. This is a marketing model. Actually, every CA professionals, they should preach and propagate. And they should also assist for selecting the best BRP. Compliance level, CS can do it better. So that's why it is really very important. They can arrange investment in stressed assets. They can appear before adjudicating authority. Their role is very, very important, very much important, debt restructuring and liquidation, because they are having expertise and acumen. They have the rights and duties and obligations, and also ability to draft agreements and other issues. They have the obligation as CD and guarantors. And finally, they are friend, philosopher, and guide to both CD, FC, and OC, their education and training. The role of CS, very, very important in this process. So before concluding, we'll say that it is an important advantage for PPRP to protect against business disruption. That should be our role, to see that business continues. There is no loss of goodwill, no disruption in business, no job loss. It is a flexible approach. It is a speedy and collaborative process for resolution of financial stress in the MSME sector, especially in a scenario where the base resolution plan is accepted. The process is potentially far speedier and more cost effective than a CRP process. So CAS must try that BRP is passed and submitted to, approved by the COC and submitted to adjudicating authority. So the key to the success of PPRP as a speedy and efficient mechanism lies in adherence to the time limit, timeliness, and a proactive approach of the stakeholders. So here we will say the role of CA is very important for guiding the stakeholders, for expediting the process, and following the timeline. There may be challenges to timely completion of the process due to reliance on the adjudicating authority and NCLT to approve the resolution plan even after COC approval. The requirement of a Swiss challenge process where the base resolution plan is rejected and the need to achieve a cooperation between various classes of stakeholders. So these are the basics. Thank you very much. And especially this, they have to follow. If their wrinkles are there, it should not be on the heart, it should be in the face. Spirit should be there. So PPRP process requires a good spirit. Spirit should always be young in implementation of PPRP. Thank you. Thank you very much. Any question? We are ready to reply.
Well, Mr. Panigrahi, when you said that for FC it will prevent slippage, it means that classification as NPA is not required to initiate pre-pack.
In the process, when we are going for, it's a, sir, actually it's a legal restructuring. When we are going for resolution of a standard assets, the main point is that the banker should be very alert regarding two issues. One is
standard asset, I can understand. I'm also a banker. But the point I want is, so the question of default, proving default does not arise here. Is it so?
No, default is there. Default is there because when there is SMA means default period starts.
Okay, understand. So
here default is minimum 10 lakhs.
Classify as NPA.
G.
Okay.
Here default is minimum 10 lakhs.
Default is 10 lakhs.
No, I am not telling about the amount. My only question is that when you wrote as a first point, prevention of slippage means that it is not necessary that the account should be NPA to initiate the pre-pack.
Sir, if default is not there, minimum 10 lakhs, we cannot initiate the PPIRP.
No, the question of the process.
Sir,
clarify that it should be NPA.
Let me clarify, sir. Actually, when the accounts, when MSME accounts under EWS or SMA category, or prior to that, this PPRP process should start. These warning signals are always with the bankers. So banker role is very, very important. This is where the bankers are lagging, frankly speaking. They are not guiding properly the CD for resorting to the PPRP. If they do not go, then it will be NPA. NPA means the bankers, they go for SARFAESI or DRT like that. They go for all these litigations. Prior to that, they should do it.
But it is not binding for the banker. That is the biggest thing. Nowadays, bankers are straight away taking attachment and all those things. Correct now? When there is an opportunity is available to give a decision to the CD.
Sir, a question.
Yeah.
So that means if the company is an NPA, then it will go into CIRP, and pre-NPA case, it will go into PPRP. Is it so?
It all depends on the MSMED Act eligibility and amount.
Yeah, it is. If it is MSME, it is eligible. If it is not, it is not eligible.
Now, clarifying to that, madam, see, CIRP is started by initiation of FC or OC or company itself. But in this case, the MSME company himself is going to the banker with a recall. If it is rejected, then they have a right to file under section 54. So it's a different angle process. Got to clarify or what, madam?
Sir, what is the response? What is the response of this case PPIRP? Since beginning, how many cases are there in?
Only one case only I have noticed so far. Okay, the reason which I was clarified in the beginning itself. There are many situations that banks are not even aware about these provisions, and MSME promoters are not aware about these provisions. Correct. And if at all they knows it, the promoter feel that if they rejected and then started invoking the property and all, it will be a big problem. Okay, so it is a mental agony for the promoter to take charge of it and take it into the in front of the banker. Banker is also brilliant. He think I am fully secured with his house and all these ornaments and all those things, all property. Then why should I compromise? Correct. So bank is rigid, whereas CD is afraid. Because if CD is afraid, immediately he will start litigating, and his private property, his personal property, whosoever given personal guarantee, and all these things are going to invoke. Correct. And most banks are straight away going to DRT where the personal assets are involved. They are not even going taking the route of the CARP. Right. I have come across a case that they are initiated surface and going to recover the guarantor's house and all those things and sale. And they will do very quickly and without giving opportunity. So the guy is now going to present the opportunity of this PPIRP request. If bank is rejected, immediately that MSME is going to file to the NC adjudicating authority for invoking it. The thing we insolvency professional come about it after the situation is very serious. The medical college says, and if you come before 2 days, I could have saved the patient. So like situations are happening. Correct. So it's required a total awareness to the MSME as a whole. So we are organizing to get conducted with all the trade associations and MSME department even to get it revamped to the extent what is possible, so that much of the IPs not getting any assignment in general could able to get facilitated in the way maybe. These all are attempts, sir. These all what we are doing, all are attempt. What is the best thing we can do for the national building process? Companies to help it out. This is what.
Sir, as a banker, I'll say every bank and financial institution, they should have a board approved policy.
They will go with their policy.
Panigrahi, it is not a question of policy or anything like that. It takes time because bankers are first worried about the bad loan, okay, and they are so preoccupied with something else. Actually, that's why these things are happening. It's
Yes,
not
yes.
that bankers are not aware of it.
MSME, actually, sir, MSME department of each and every bank and NBFC, they must have a board approved policy. It is mandatory regarding this. If a bank is not having a board approved policy and execution, strict execution, they cannot get the benefit of this process.
Panigrahi sir, can you close this screen sharing so that we could see each other in a big platform and it will help you also.
Yeah. I'm closing.
Yeah, please, sir.
It is closed.
No.
It's not closed.
It is above the screen. There will be stops.
Right.
Now
It is closed.
Panigrahi sir, you are heading the MSME sector when you are in Union Bank. That's what I know. Correct. So what was your attitude when you are on the position to the team who come to you or door to asking for an arrangement, compromise, settlement? What was your reaction? Because you might be reacted as per the policy of your bank. Panigrahi sir, it's not there.
Yeah, I'm here. In fact, this department of any bank, I'm telling, there is a direction of RBI that this is to be taken as a board approved policy. But how many banks have done it? Those who have done it, they are ahead of. And how many banks have really filtered the MSME segment eligible for quarterly finding the eligibility? See, today is a date of today is an age of data. So data driven, in a data driven age, it is a benefit for both the bankers, CAs, and others also. So as CA, we can get the benefit of data, as banker also we can get the benefit of data on MSME. So how many accounts are giving causing concern? How many accounts of 10 lakhs up to 1 crore they are under EAS and SMA? Whether this PPRP can be benefit, whether the process can benefit those. If this analysis is done at the bankers level, and during the course of audit of MSME department, the chartered accountants they must also suggest them that this exercise is to be done. In a branch audit also, we should suggest the branches that this process is to be made applicable so that the benefit, because CDs, they lack knowledge of this PPRP. Really, we have interviewed even bankers. They do not have the knowledge even up to the real manager level. They do not have the knowledge and idea about this PPRP process and the benefit that they can give it to the CDs.
It is very much true, sir. We used to get call from the bank for
So
clarification of certain points.
bankers, banks in their training system should make it a proper growth driver mode, so that they can provide the benefit.
Sir, banks have the MSME loans and they are promoting MSME loans on media.
That is for mitigating the target, sir. I just tell you a wonderful example.
Exactly.
2 days back, I was consulting a company. You know what happened? They were given OTS and they paid 75% of the money. But after giving OTS, but well before giving OTS, this bank is initiated CARP on this company. And after paying 75%, the order comes. Okay? Then NCLT understood the fact of this fund. Then what NCLT did, they themselves recalled their own order. Okay. See how brutally the bank is handling this case. That company is backed by 2,000 employees. I'm not against the bank, but I'm telling you, the awareness should be there. And NCLT order, NCLT themselves backed, can't back. Matitharan sir is a GM from SBI and having much experience in the risk management of the SBI. So Matitharan sir, could you please enlighten us something on this ground?
Yeah. See, it is not a question of policy or because as a CR of the bank, I'm the master of policies for vetting all the policies actually. It's not a question of policy. MSME department in any bank for that matter is currently only a development department for credit. Okay. It's not for a stressed asset management. When it comes to stress, it goes to a different vertical. That precisely is happening. Okay. Then the question of the bankers really wake up when the accounts become NPA. Till they wake up, they go on some more, they're playing with that and see that the account doesn't fall to NPA. See, pre-pack is something, we can say it is brand new. It is yet to hit the actual bankers who are actually managing the stress of the bank actually. Currently, the stress management is a different vertical and that is being managed under the existing laws actually. The new pre-pack has not really hit them. Okay, and they haven't thought of having a pre-pack when the account is under SMA as said by our Panigrahi. That has not come. So because it has not hit them. Panigrahi is correct actually. The operating functionaries, basically the operating functionaries, the branch managers, regional managers, or in the zonal heads, they are not aware because they are driving the business. Okay, when it comes to stress, it goes to a different vertical because this requires a specialized attention. And also, there is something which you have to accept that the bankers also have to share a haircut when it comes to PRP. There will be a haircut. So the acceptance of taking that haircut, that also has to come. It will get evolved. This is my view of the situation.
The percentage of the MSME is also very low, na, for whom this policy will be applicable. The percentage is very low. It is not applicable for all MSME. That is also an issue, na.
It is applicable for all MSME.
No, only corporate.
Okay.
Only corporate.
That only corporate. Currently it is only corporate which has come. Correct. You are right.
This is the main issue.
Okay, all those.
In my view,
Yes.
Vinodji can tell. Vinodji can tell.
Yeah, majority of the MSMEs are in the
Partnership firms.
Yeah, absolutely. Sharma, you are right. You are absolutely right. Okay. That's one of the valid reasons why it is not popular.
Yeah, the issue with the partnership and its regulation not notified, because there is, you may be aware about it, concurrent list and state list, all those things, and a central and state. The partnerships are state laws. Partnerships are governed. It's registration, not partnerships. I'm sorry. The what do you call it? The registration is under the state law. Now the problem when partnership is the partnership under IBC is drafted and everything is in there. But for notifying, in my limited understanding, state record, central record concerns of each state. So that is the reason why it is not coming up. But once it is coming up, the current NCLT facility is not sufficient.
Exactly.
We required a huge medical college setup for the NCLT, because it should have that much of facility. Number one. Number two, the current NCLT is not able to handle the cases as per the provisions. So Central Supreme Court made everything as mandatory, not mandatory but regulatory. Correct. All these are because the system is there, but the body which is there is not capable and having the capacity to take all the matter in the way it is required. This personal insolvency is invoked, then it will be very painful things to go and recover the debts from the individual and all. You may be seen some Hindi film which is very renowned Hindi film of recoveries and raid and all those things. See, the position is that now we know that in the company insolvency process, many cases are coming to the IP who is listed in the adjudicating authority that there is no asset, nothing, simply file the cases, and people are pledging their gold from Muthoot Bank to get fund for giving advertisement and other expenditure. Because even after NCLT order, they are not getting the fund. So, having said all this partnership, individual insolvency, but it will take its own time and it is not expected in another 5 years at least. That is the reason why the limit of earlier 1 lakh rupees is extended, enhanced to 1 crore rupees, because it is not possible to release to come down to 1 lakh. If it is come down to 1 lakh, then NCLT is to be rebuilt as in the capacity of a medical college. Correct. So considering all these things are happening, but at large we are talking about MSME and its importance. But MSME is not able to recover its debts, its dues from the corporate. He has to wait to get accumulated the amount till 1 crore. While we are talking a lot of things, my dear friends, it is very bad thing that MSMEs are not able to approach NCLT for recovering their debt. And if they approach DRT, DRT will not take the case. They say, this company jurisdiction, adjudicating authority is NCLT. If they go for civil court, then they say, this is company, the jurisdiction is NCLT. NCLT, they don't allow to take the case. So one side we are talking about big thing about MSME, other side we are not worried about their recovery process or their revival process or their working capital management process. One side, this PAP, this process of MSME resolution is there, which bank is not properly aware about. If at all any resolution put up to the bank, immediately they will call off the personal guarantor and start harassing the things. So what is required is educating both the system, the financial system, the financial institutional system, as well as the MSME system, for which there is no drive is happening. So we thought from our platform we will talk on this subject so that MSME gets some attention and also think about having a wider scope, wider infrastructure for the NCLT so that the litigation can be even take up for the 1 lakh. At least I'm not talking about 1 lakh, it should be at least 10 lakh. Correct? They will be able to recover their funds. And bank is only, see, financial institution should be recover the money because they are the funding for the Indian economical development and for its back office. On the other side, it is telling that MSME is the backbone of the national economy and they should be protected. Do you think that IBC financial institutions are not able to recover the full money, whereas MSME is not claim his outstanding from anybody. Now, where we are. So these things we have to debate better, and we have to take it into further platform. Panigrahis are just
May I
people.
intervene here?
Yeah, I'm just concluding, President.
Yeah.
So you all are experienced people from the banking sector. So we all together have to find out a drive to come out from this. Yes,
In fact, in banks, large size banks, there are 3 different departments. One is MSME, looks at achievement of target, business growth. Next department is monitoring. It monitors, it regulates SMA accounts, EWS and SMA accounts. Once it becomes NPA, then recovery department. So who will execute this PPIRP? Responsibility with whom it is to be vested? Whether it is recovery department as IP, when we meet the recovery department, they say yes.
I should not comment upon it.
Whether monitoring department will be taking a leading step. Monitoring department says no, this IP we do not handle, it is all handled by the chief law officer. Chief law officer comes under recovery department. So PPRP cannot be taken up.
Yes, sir.
So these 3 different departments not having a proper coordination in resisting the slippage, practical resistance to slippage, that is the call of the day. Then second one, legally speaking, when we are giving a scope only to MSME from 10 lakhs to 1 crore, why not for other segments? The PPRP process can also be given a scope to other segments.
You are absolutely correct, sir. You said all the slippages, correct? Then why everything is implementing on one side, on the other side without thinking foresee? I should not talk on this matter, but there is no way. We have to just comment only. One side you are made all these laws and regulation. Other side, the government agencies like RBI and financial system is not coming up and educated the thing. And only one segment of MSME is given facility. Other individual entrepreneurs are not given any opportunities. All these are very imbalanced items. So I don't know when government will be looking to this in a different fashion, or it is there only just a gimmick for recovering the high outstandings, and it may be come up and end with when these all overall recoveries are happening, and IP we may be shut down with a board that IP without any activity, or we have to go back our own home business to practice and all. I don't know, but these are all the apprehension. But let us forward find out some source of gathering together the whole energy to get revamp into the thing. Correct. When PAPP was introduced, IBBI budgeted about 25,000 IP opportunities, if I am right. Okay. At least 500 IP could get a work currently, that will be good enough. Right. Anyway, time is going up. People are having something to discuss, then we can take it up. Otherwise, we should bind it out the program. That's what I think.
Vinod, actually, when we referred about NCLT, I found out that way back when the DRT was formed, as back as in 1993 also, when I was a young officer in the bank, we were told that it is for quick resolution within 6 months. Okay. And it is for that purpose, it is a tribunal. And that tribunal was distanced from the Department of Justice of the Government of India. It was brought under the Ministry of Finance. So the tribunal's presiding officers are no longer part of the Department of Justice. They were appointed by the MOF, Ministry of Finance, and they are supposed to summarily hear the things and dispose of the petition. And then there is a recovery officer in every DRT, and he is supposed to recover everything. All these things, nothing happened. Okay.
Counter to that, sir. You all mostly aware that I'm a final student of CMA. I'm having surface active study. So it starts with that for the easy recovery and the most effective way of recovering the money. Surface is there. On the 90 days of this thing, give a notice and recover everything and all those things. Correct. But where we are from the reality and what we are talking about are different. So, yeah, back to you, sir.
Yeah, actually, therefore, see the constitution of the NCLT, which is a product of the Companies Act. Okay, with the judicial member, the other member, they are holding the proceedings like a court. This has to stop. It is high time this has to stop. They have to dispose of things in a manner without any protracted, like the conventional roll call of the court. All these things, we should have a different thinking. Otherwise, the NCLT and IBC things are the same fate of the DRT. DRT proved to be worthless because I have experience when fighting with the DRT in many two metros, and I personally go and attend. I find they are worthless people.
You mean arbitrary type of arrangement? That's what you mean?
No, the point.
Arbitration.
First of all, they are functioning like a typical courts, and they are not deciding on anything. They have to see the papers, and they don't have to have these protracted long postings, all those things. It is now happening in NCLT also. Very lengthy posting. Okay, even for admission of case, why should there be a hearing? We can see the documents and admit the case. There is no need actually.
If it is admitted the next day, NCLT, the case will be listed in NCLT.
Let it be. NCLT also, all those things which carries this tribunal has to change. The constitutional questions will be addressed by the Supreme Court or High Court. But these tribunals have to change the way of functioning. Unfortunately, this tribunal, which is the creation of the Companies Act, they are functioning in their old-fashioned style. It will never improve.
They should have a target like others.
Exactly.
Because they are dealing in business
target
units.
tomorrow taken to Supreme Court, and it will say it is not mandatory, it's regulatory.
See, over a period of time, Supreme Court also will change. See, everybody thought that the Rajiv Gandhi assassin people has to be kept for years in the jail. They are also released. So the time will change everything. But the original purpose of IBC was for a faster disposal, value maximization. That has not really happened. See, originally driven for the dirty dozen. Okay, all those dirty dozens, the haircut which is suffered by the bank are enormous. Okay, it is close to 80-90%. Okay, it's enormous. So it's a hit on the public funds. So the purpose of so-called value maximization has not really happened in those big cases.
Actually, in fact, there are certain underlying issues which can't be discussed.
Yes,
bottlenecks are there.
So many bottlenecks
are there. Practical hurdles are there.
In my view, it's a mistake for IBC to entrust these IBC cases to the existing NCLT, which is a creation of Companies Act. It's a wrong decision.
It should be an independent board with a target. No pendency timeline.
We will take it up for a separate discussion. Since this matter come to us, we will also think that we can schedule a meeting for this particular matter separately. And the time is going to be 7:30, sir. We have another meeting scheduled at 7:30.
Yeah.
We have to leave and get ready for the other thing. If Panigrahi, sir, if you are completed, with your permission, we can move for the closure process.
Yes. Thank you.
Thanks, sir. Thanks, sir.
Yeah. Santosh madam, are you, Vimal Kumar ji, yeah, please. It's your time to get close the meeting, sir.
Hello.
Yes, Vimal ji.
So, Mr. Panigrahi is a seasoned banker. He has retired from as GM from Union Bank of India. Incidentally, I am also from same bank as Corporation Bank has been merged to Union Bank of India. He has presented PPPIF in a very nice way. All the members will definitely be benefited with his knowledge sharing. I, on behalf of myself, members and TIPPL, thank you very much for him for such a nice, fruitful session. I hope we will have such knowledge sharing sessions from him in future also.
Sure.
Very.
Yeah, thank you all. We have to bind up because of the emergency. Okay.
Thank you.
And people have taken the opportunity very nicely to debate and discuss so that this is an open platform. We don't deprive anybody to come with the idea, ideology, and ethics and analysis.
I'll request him to give this presentation.
Yeah, that will be provided, sir.
PPT presentation if
that will be provided. That will be also attached to the YouTube link.
I'll share it.
Anybody,
please.
anybody go and see the YouTube can also.
The recording has stopped.
Thank you.
Thank you.
Thank you. I had given a presentation to NIBM on this also.
Okay. All right. Okay. Bye-bye.
Thank you. Thank you.
Okay. Thank you very much.
Thank you, sir. Thank you.